Good. So this, if you want me to say what I did this last month, I guess, I spent a good chunk of last month on what I alluded to earlier was an election case. Was Wickstrom versus Johnson. And that took, that, that pretty much ate up 2 of the weeks of my month. And that was hearing the evidence, hearing the arguments, and writing the opinion, and trying to figure out exactly what the law required me to do. So that was a good chunk of my month.
And I have to put in a plug here because of all that hard work. The League of Women Voters will have a candidate forum because of the decision that was made, and there will be a new election. So if you are available on Thursday, January 16th at 6:30 at the Roseville City Hall, there will be a candidate forum. And the election for that open position in Minnesota House District 40B is Tuesday, January 28th. So you are all aware of that, and we do have some flyers in the back. But thank you for your hard work with that, and we will move on.
All right, day-to-day work, typically I start early in the morning with meetings, frankly, before the court day starts. In criminal, most of our time is spent on the bench in court. We have a very small fraction of our time that is spent in chambers doing desk work. We kind of have to fit that in during the breaks and frankly over the lunch hours and whatnot. So a typical day for me involves a meeting before the morning calendar starts, court, typically between 9 a.m. and noon. This past week I was in a trial week. We're on a typical rotation where we'll do trials for a week, then pre-trials for a week. Those are the hearings that lead up to trials. We will often spend a week hearing cases at the jail, first appearances, and making bail determinations on people who have been arrested. There's some variation of that rhythm. So this past week, court from 9 to 12, meetings from 12 to about 1:15, back on the bench at 1:30, and court typically ends at 4:30 in the afternoon. Well, sometimes we end a little early, and those are the nice moments when you can get some signing done, get some phone calls made, maybe run down the street and grab a sandwich for lunch if you're lucky. But we don't have an incredible amount of time built into our work days to get the administrative work done, and it still needs to get done. So that's one of our pinch points. I did hear this past Friday, my trial ended, so I was able to cover another calendar, a pretrial calendar. Those are typically 20 to 30 some cases that are on in a 3-hour period. So they're very quick, and the criminal rotations are like drinking from a fire hose. It's a lot of cases in a short period of time. So it's just the opposite of the civil rotation in terms of fast and furious and less time to consider what's coming at you down the freeway.
By sharp contrast to the work of the district court, the work of, I think, appellate courts is quite different. Having come from the district court and then being an appellate court judge, there's a lot more time and space to consider really complicated issues or issues that have become more complicated as the case has progressed. I don't think it would be that interesting for you to hear about all of the administrative work that I've been doing in the past 12 days. So I think it would be a better use of my time to tell you what a typical appellate court judge does on a day-to-day basis. So there are 19 judges on the Court of Appeals, and we organize ourselves into panels of 3 that consider cases. The court handles about 1,800 cases a year, and every month each panel has 4 calendars typically, and on each of those calendars there's 6 cases typically, sometimes more, sometimes less. And those cases consist of the entire trial court or administrative record. So in order to prepare for those cases, you have to read everything that happened in the entire proceeding on a particular case that occurred in the district court. The parties have an opportunity to submit briefs, legal memorandum that explain what the issues are that they're seeking reversal on or affirmance on from the Court of Appeals. And then there's all of the legal authority that's cited in the cases, statutes, rules, case law. And so it's our responsibility as an appellate court judge to read and master all of that information on every case that we have, because every single case is important to the parties, it's important to us, and it's important that we get it right, and it's consistent with the legal principles that bind any particular case. And so we get ready for the cases. We have oral argument on many of those cases at the party's option for people who are represented by counsel. And then we will conference as a panel and make a decision on the case. And then there's an opinion writing process where we write a written opinion in every single case. Not all appellate courts around the country issue written opinions explaining the basis of the decision that's reached. In Minnesota, we do that. We feel that it's important for the litigants to fully understand the reasons why we're making a decision, what the basis of that decision is, and to clearly communicate that. And so we issue those opinions within 90 days of hearing the case. And also, we are the only court in the country that has a 90-day deadline at the appellate level. So we are a high-volume, fast-moving court. And although we are not seeing people all day, every day, and handling cases at the volume and pace of a district court, it is a relentless, constant workload to stay on top of and to produce the quality work product that we do, and hopefully not have it undone by the Minnesota Supreme Court, which doesn't happen that often. Doesn't happen that often. I'm hinting.
All right, so yes, it is the appellate level, which I am also at as a member of the Supreme Court, is much quieter than the district court. And I was a district court judge in the beginning, and then I had the opportunity to work with Judge Frisch at the Court of Appeals, and I remember the transition from the district court, where you have people coming into your courtroom all day long, and you have the opportunity to interact with members of the public, attorneys, probation officers and other people serving the courts, getting to the Court of Appeals then and thinking, this is very quiet. And if I thought that the Court of Appeals was very quiet, well, the Supreme Court is even more quiet, because unlike the Court of Appeals, which has 19 judges, we just have 7. And we decide our cases all together. So the Court of Appeals sits in panels of 3 judges. We, as a group of 7, will consider and make a decision in every case that we touch. And unlike the Court of Appeals, which does not get to select the cases that come before it, the Supreme Court does. So a large part of our work is actually picking cases that we will be hearing. And there are certain criteria that are set forth in a rule that that we consider in deciding what cases to take. And essentially, we take those cases decided by the Court of Appeals that present issues of statewide importance, that interpret the Minnesota Constitution, that interpret a Minnesota statute that has yet to be looked at by our court, or those very rare cases where the lower courts, in the estimation of the Supreme Court, have departed from the usual course of justice, where there's some, significant injustice that has occurred. So a lot of our work is considering requests to take these cases. We don't just reach down and take cases that might interest us. One of the parties has to ask us to take the case by filing what's called a petition for review. And we get those petitions for review. We read the decision of the lower courts, and we gather as a group and we vote on which cases to take. If 3 members of the Supreme Court would like to take the case, we take the case. If fewer than 3 members of the court vote to take the case, we do not take the case. Once we've taken a case, we kind of go through the same process that happens at the Court of Appeals. The parties have an opportunity to file briefs. The judges read those briefs. They read the entire record. Very often, there are others who file briefs to our court called amici, friends of the court. Different organizations that would like to have some input into the rule of law that the Supreme Court is going to be adopting. So we have to read all of those materials. And then for the first 2 weeks of most months of the year, the Supreme Court hears oral arguments. And this is sort of a supplemental opportunity for the attorneys to persuade our court of their positions. We hear 2 arguments a day, and then as soon as the argument is done, the court goes into conference and makes a decision on the case. And then one justice is assigned to write the opinion of the court. Unlike the Court of Appeals, we have a few or more than 90 days to issue the decision in the case. And sometimes you'll see multiple decisions from the court. If there's disagreement, for example, there can be a dissent. If one justice agrees with the outcome of the case, but maybe disagrees with the way that the court gets there, there can be a concurrence in the case. And so following that conference, the court works to get a finished, polished decision that contains the law and the views of any justices who may disagree, and to release that opinion to the parties and to the public. And then that decision goes in the law books and becomes the law of the state that controls future cases going forward.
I apologize for the mic situation. Normally, I wouldn't be bopping up and down. But we mentioned precedent. We mentioned legal principles. That means a lot to those who are lawyers or maybe those that have experience in the law, but it may not mean a lot to our citizenry. So I would like to hear more about what you rely on when you make a judicial decision. Precedent, rules of evidence, civil rules of procedure. There's a whole ton of things that you have to rely on as a judge. Can you explain some of that to our citizenry? Judge Castro?
So when the Court of Appeals or the Supreme Court issues a decision, I am required to follow it, whether I agree with it or not. So that's the reference to precedent. So, and the rules that the legislature puts together or the courts put together, the statutes that the legislature puts together are what guide me in my decision making. Where they put an and or an or a comma makes a difference. So all those things are important to us. And, you know, sometimes, as was mentioned, there isn't a decision in Minnesota from the Court of Appeals or the Supreme Court on a particular issue. And so then I would tend to look to perhaps other states or the federal government, the federal courts, to make a determination that would guide my decision making in that process. I'm not bound generally by those other decisions, but they would inform my decision going forward.
I don't know that I could add much to that. I think you'd rather hear from these folks.
I'll take my shot at it now, Justice Gaïtas. I think there's a misconception that judges can just do whatever they want, and that is not the case. Judges are bound by the rule of law, and I know all of you have heard that phrase before. Our authority is granted to us by statutes, by precedent, binding precedent that has been issued by the Minnesota Supreme Court, which sets forth the law in the state of Minnesota and rules. And judges are duty bound. We take an oath to follow the rule of law, to apply the principles of the United States and the Minnesota Constitution. And I know, having worked with each of my colleagues up here, that we take that oath extraordinarily seriously, that it is our responsibility, even if we personally disagree with a principle of law, to follow the rule of law as it is established in the state of Minnesota. And that's because that's the foundation of our democracy, that we are a nation of laws and rules, and to provide transparency and predictability for citizens, we must be an orderly, law-abiding citizenry. And so when we talk about precedent, when we talk about the rule of law, we're talking about statutes, duly authorized statutes. We're talking about principles of law that have been announced by the Minnesota Supreme Court or the United States Supreme Court, whatever is binding on Minnesota courts. What did I miss?
That was pretty good. So I think one basic misconception that that people have about the judicial branch and judges is that, especially appellate judges, is that we're just like making law. And it doesn't actually happen that way either. We are interpreting and applying law typically that the legislature has made. And the way that precedent sort of develops is by taking that law and applying it to unique sets of facts in a case. So we have to have a case in order to make a decision. And, each case has a very unique set of facts that is presented. And then as judges, we have to take a statute, figure out what it means. And sometimes that can be really tricky. Sometimes it's not clear at all what a statute means. And so that's where you may see some disagreement about judges. It's possible that we're all looking at the same thing and seeing something a little different. And then how that particular law applies to the set of factual circumstances will then create a new rule of law, will then create a new precedent that the court can later go back to in a new case and ask, well, what did we do in that case? We had that statute. We said that that statute means X. We had that specific set of factual circumstances. Well, now how is it going to apply here where things are just a little bit different? That's a very sort of basic view, I think, of what appellate courts are doing on a day-to-day basis. And it's really not about making law. The legislature has the authority to do that. And so our role, again, is really interpreting that law. And when we're interpreting that law, we rely on various sources. We rely on our past case law. We rely on certain rules that exist. And the legislature has actually passed some statutes that give us some direction about interpreting what they're saying in their statutes. So we apply those statutes and we try to do our best to glean, what the statute actually means. We rely on different rules, court rules, for example, in trying to make our decisions. And you put all of that together, and you get our opinions that we discussed, and those are a written explanation of what the case is about and how we reached our decision under the law.
Okay, next question. Training. You're supposed to be knowledgeable in the law, and generally that's considered if you've gone to law school, although professors would probably say if you aren't knowledgeable in the law even after finishing law school, but regardless, all of you have gone to law school. You've had careers as attorneys, but before you got on the bench, tell us about the kind of training that you received from the point that you were appointed until you started actually doing the performance in the judiciary.
Well, generally speaking, in Minnesota, there's only two requirements to be a judge. You have to be a licensed lawyer in the state, and you actually have to live in the district that that's that you're appointed or running in. I didn't mean that. I did. Um, oh yeah. Well, so and yeah, you have to pay the filing fee, right? So, but so you can be out of school. Graduated from law school in May, been sworn in October, and then run for election for empty seat or a vacant seat or a contested seat in any particular district. And I know we're going to talk briefly about the Judicial Selection Commission, but as far as training, I think in most part, your training comes from your experience. We all bring different backgrounds to the bench. I was a public defender for 20 years before I was appointed by Governor Dayton in 2012, and we have certain requirements as judges to do so many hours of training a year. We have certain requirements as licensed lawyers to do so many hours of training a year. So, but there's nothing that really specifically says you have to do this area or that area. I had very little experience in civil law when I when I became a judge. And when you come to find out, even the experience you do have as a criminal defense lawyer, there was still so much to learn. After doing it for 20 years, there was still a ton to learn. We rely heavily on each other, frankly, and we confer with each other often on issues. So.
Maybe I can pick up from once folks are appointed or elected. We have the luxury in Ramsey County of having 29 judges on the bench. And so we rely on the expertise of each one of our judges to help train in new judges. We have one of the lengthier training programs for new judges when they start. Now, we've recently had 5 new judges start on our bench that we've put through training. We start them by observing. We walk them through different calendars and let them just watch. They may or may not have experience in whatever division that they're starting in. Historically, we start people in the criminal division. It's high volume. We start them on misdemeanor cases, so less serious, and I put a huge asterisk on that because every case is serious to the people that are involved in that case. So we start them by observing, then we start having them reverse shadow. We have them handle a few cases on the calendar. We have formalized training that we do outside of the courtroom about here's everything that you're seeing. That training is with judges, it's with court administration staff, it's with our justice partners. And what I mean by justice partners in the criminal division in particular, that's our public defenders, our prosecutors at every level. It's the folks that we're dealing with in probation, our pretrial services folks. It's every other organization, every other profession that touches everything that we do in the division. And we do this in all of our divisions. And we essentially start every new judge on a very gentle ramp to get them going. And we give them feedback and more feedback and more feedback. And we encourage the folks who are appearing in front of them to do that as well, and the new judges to be receptive to that as well. You don't know what you don't know. It's very different when you take the bench, even when you have practiced as an attorney out doing it. When you're on the other side of the bench, it's a whole different world. And the world of responsibility on your shoulders is very heavy when you start. So we make sure that we have a lot of support in place for folks and put them on a very gentle on-ramp when they're starting. The training that Judge Castro referred to, so we've got our internal training in our district, the state Judicial Branch puts on extraordinary training for us as well. We have 2 trainings that conferences that we have during the year, and then a number of trainings on any manner of anything that we deal with that are available both online, in person. And so it's an ongoing serious endeavor to make sure that we're staying on top of it, because these folks, they change the law on us as well. So there's always something new to learn.
So I was a civil lawyer, unlike Judge Olmstead and Judge Castro. Before I took the bench, I was in private practice and represented private clients for about 8 years. And then I was in-house counsel, trial counsel for the University of Minnesota for 11 years. So I had seen the inside of the courtroom quite a bit, not as much as criminal practitioners, but I was very familiar with how to research new areas of the law, the procedures that govern the proceedings in court, evidentiary rules, et cetera. And having that expertise gives you a really good foundation to learn the things that you need to know in order to be an effective judge. And dealing with people who are unlike you, who come from all walks of life, also gives you a good foundation of handling high volume calendars with a lot of people from different backgrounds. And so those kinds of skills, I think, develop over time and with experience. So to piggyback on what Judge Castro and Judge Olmstead mentioned, there is a lot of formal training, and there's a lot of opportunities to observe and to have people observe you at all levels, including at the Court of Appeals. And we have mentors and institutionalized feedback to help judges develop. And I will just say my colleagues are very humble and very receptive to hearing things that they could do that might be better received by our litigants and our participants, and including myself. And one of the things that is so great about being a judge is that for me personally, besides the service that I provide to the public, is that I'm a very curious person, and I'm always learning something new, a new area of the law, a new way to do things that might be better or be better received. And to continue to improve and progress is I think, a constant that you will see through most judges, or almost, I would say all judges in the Minnesota Judicial Branch.
You guys forgot the baby judge school.
We have baby judges.
So, so one other component of the training that new judges receive in Minnesota is a statewide program for all judges, and it's informally referred to as the Baby Judge School. I think it's actually called the New Minnesota Judicial Branch New Judge Training, and that's a week-long intensive program that helps new judges get on the same page and come together and share the very different experiences that they might be having, but to ensure that there's some uniformity in the practices of judges throughout the state. And, you know, we've talked a lot about the work of metro area judges. I was a Hennepin County District Court judge, and in Hennepin County, they have a 6-week training program when you first come in. You don't even get to a courtroom for, you know, probably 4 weeks. And it's very formalized, very intensive. But that kind of program does not exist throughout the state of Minnesota. And there are judges outside of the metro area who do not have the opportunity to specialize in civil or criminal. They take the bench, and they're maybe the only judge in their county. And they are expected to handle family law matters, criminal matters, probate matters, civil matters, all in the same day, while at the same time being the only judge available to sign search warrants when law enforcement would like to conduct a search. And so the experiences of our judges throughout Minnesota are very, very different, just simply based on your location. And for that reason, it is important to have some sort of uniformity in our training. So the baby judge school, the 2 conferences that we have every year, and then constant sort of online training is really helpful for making sure that the judicial officers in our state are unified in the practices that they're engaging in and the decision-making processes that they're using as well.
Well, not going quite in order, we skipped to training, but how about judicial selection? It's complicated. I've been an election judge and I can comment on the number of people that will walk up and say, do I have to vote for all these people that are on the back of the ballot that are judges? Many of them appear to be uncontested. Once in a while, they're contested. We have appointments, we have elections, we have contested elections. It's pretty confusing. Maybe you can describe what you went through as you became a judge. I don't believe any of you were ever involved in a contested election, were you? Nobody here? Okay. It's a rare thing. But describe how you got to be a judge. Oh, one more thing. Also tell us about the uniqueness of your personality and background that you stood head and shoulders above the rest to be selected.
Well, it took me 3 tries, so I don't know the uniqueness. But I wasn't born in Minnesota. I'm born in New York and grew up Chicago. I call Chicago home. And still, even though I've been here since 1992. Um, and my background is that I grew up in the inner cities of Chicago and New York. I joined the military right out of high school. I spent 8 years in the Air Force where I was able to go to night school and get my undergrad degree. And then the state of Illinois continued the GI program, and they were able to send me to law school for free. So, and then I came to Minnesota in 92, and I started working as a public defender in Southwest Minnesota. I became chief public defender in Southwest Minnesota. Then I was chief public defender in Hennepin County. And then after doing that for, I don't know, about 14, 15 years, I then went back to Ramsey County, some public defender work, and then Governor Dayton appointed me. I was on the Judicial Selection Commission actually during the Pawlenty administration. And the vast majority of judges are appointed, initially appointed by the governor. The only time, and I don't know if I have this rule particularly right, but there, if there is a vacancy at the time that the judge is running for election, that's the only time that generally people are elected to the bench, or if there's a contest. If a sitting judge is being contested, then that's the only time that folks are initially elected. But the vast majority of judges are initially appointed, and then we need to run for election in the next general election, which is within 2 years. We're required to run, and then it's a 6-year term. So I don't know what stood out for me. Well, I don't know. I've never had the chance to ask Governor Dayton why you appointed me. So, I think it was a combination of my experience, um, of, frankly, my military service as well. I think all of us bring unique backgrounds and perspectives that inform our decisions and inform how we interact with the people that appear before us. So I was very fortunate, and I will tell you, it is the best job in the world. I love what I do.
Well, I have to echo that. It's an awkward question to answer. No, either. I can talk a bit about my background. I grew up just up the way here on the east side of St. Paul. I went to night school for college at the University of Minnesota, worked my way through college, worked my way part-time through law school as well at William Mitchell, and started clerking at the Ramsey County Attorney's Office when I was a law student there. I worked for a number of years in private practice and civil litigation when I first graduated from law school, and then was able to get back into the county attorney's office where my heart had remained all that time that I was in civil practice. I worked as a prosecutor for a number of years. I did primarily special victim unit cases, high stakes domestic violence, sexual violence cases, child abuse cases. And from there, it was an application process. You make an application to become a judge, and the vetting process is the real deal. Folks call all the people that you list on your application and 10 times more than that. I mean, it becomes a word of mouth, and they call just about anybody who knows anything about you and find out about your temperament, find out about how you have comported yourself as an attorney, find out about the work that you've done, the experience that you have, how you treat people, quite frankly. So they really do get down and dirty. And I'm now on the receiving end of those calls as a judge about people who appear in front of me as well. And I've come to appreciate even more now in the position I'm in today, the hard work that the folks on the Judicial Selection Commission put in to really vet out the people that apply. It took me a few times to get through as well. I interviewed with the governor a few times, and who knows? Who knows what it was that made him pick me in that moment? I'd like to think it was the experience that I had and, you know, the way that I comported myself along the way, but we'd have to ask Governor Dayton.
Yeah, this is a difficult question to answer. I think it would be helpful to explain a little bit more about the Judicial Selection Commission. This is an independent commission. There are appointees from the commission who are lawyers and who are not lawyers. They're just members of the community. And there are some appointments from the governor's office, and there are some appointments from the Minnesota Supreme Court. And there are, in the districts, there are specific members that are just appointed from the district. And so there are statewide at-large members of the Judicial Selection Commission from all over the state. And then there are specific members from each district who are appointing judges or who are vetting judges. And it is a very rigorous process. We submit 10 letters of recommendation, up to 10 letters of recommendation. We list the cases that we have worked on. At the appellate level, there are writing requirements. We submit writing samples and writing exercises that we have to do so that the commission can review our ability to clearly communicate the opinions that, or the disposition on cases that we will be asked to decide. And again, I don't know what it is that sets any particular candidate apart from the other. I will tell you that in every single, with every single opening that the commission has, they have an extraordinarily difficult job because many excellent, qualified, exceptional candidates submit their name for consideration. Highly experienced criminal lawyers, civil lawyers, people that we see all the time who are just, we're glad to see these advocates in court because they do such a great job. We're glad to see district court judges apply at the appellate level because they're so exceptional at what they do. So their task is not easy. And then the commission recommends 3 finalists, and then the governor and the governor's team will interview those finalists, and then the governor makes a decision. So it's a very rigorous process that involves vetting that Judge Olmstead indicated as well. And I think that, you know, at any given time, a district or a court might have a specific need. We're missing someone with public law experience. Maybe that's why I was appointed. I don't know. Maybe we're missing somebody with a depth of criminal experience. Maybe that's why another judge was appointed at that particular time. It's just, you know, it's a whole host of considerations that I think make the decision very difficult. But it is a very rigorous process. I'm really glad that we have this process because the appointments have really yielded excellent colleagues.
And I'll just add to that, you really don't want to have a bad judge who hasn't been vetted, because one bad egg can cause a lot of problems on a bench where, I mean, a bench like Ramsey County, there are a number of judges, but every single judge on that bench is having to keep the, pedal to the metal and work hard to get through the many, many cases that come before them every day. At the Court of Appeals, you count on your colleagues to properly review the case, to make a good recommendation to you, to write a good opinion, and to be great team players. And then, of course, on the Supreme Court, we can't have a bad egg because there are only 7 of us. And so it is just critically important that the individuals who ultimately are selected for these positions are experienced enough to do the job, are hardworking, have a good attitude, and are team players. And that's something that the judicial selection process, I think, has been, with the commission, has been very successful at doing, sort of screening out the applicants and making recommendations to the governor's office. As to the second part of the question, I don't know why I was appointed either. I had a lot of experience before I was appointed to the district court bench, like Judge Castro. I started my career as a public defender and represented individuals before Minnesota's trial courts, but primarily at the appellate level. I was an appellate public defender for many years. I also practiced in the area of civil law for 5 years before Governor Dayton appointed me to be a district court judge. I also think, I mean, maybe this is bragging a little, I'm a really kind person. And it is really important to me to treat everyone who comes before me with kindness. And that is a virtue that, that I'm pretty open about in interviews that I've had. And I at least hope that that is what, at least part of the reason that that Governor Dayton and Governor Walz were inspired to appoint me to the bench.
This part is so fun. We'll delve into this a little bit more. We'll look at it at a different angle. Prior to becoming involved with the Minnesota judiciary, we have your biographies on the Minnesota Judicial website, and I can see that all of you had amazing activities in the community. If you would think about one of the things that you did prior to becoming a judge that involved the community, that helped to formulate you, to help form you, that you brought to your role as a judge, or perhaps as you brought to the Judicial Selection Committee to make them think you would be a really good judge. If you could be so kind to share that personal aspect with us, I think it would be very enlightening.
It's a tough question. I think probably what I enjoyed the most, and it may not be on my resume, was working for Habitat for Humanity. I think, and to the extent that volunteering and building homes for individuals may have been, I think, what perhaps you know shed some light on the governor and why he would have appointed me. But yeah, it's something that not only I really enjoyed, I just found so much value in I can say that I helped this family, have a place to live. And I think it informs some of what I do on a daily basis as well. Having a better understanding what it is to perhaps be homeless or not to be able to afford some of the basic needs, I think informs decisions that I make. So yeah, and I'm pretty nice too. Kind. I may not be as kind as Justice Gaïtas, but I probably yell a little more than she does.
The habitat thing is a big deal. I used to organize groups from the county attorney's office to go and do that. I think probably my most impactful thing and the thing I've enjoyed the most though is coaching youth sports. I've coached youth softball and I've just recently stepped out of it this year and my daughter is old enough and she's moved on to bigger and better coaches. But I think that informs what I do every single day. One of the things that I love doing as a judge is developing the talent in front of me in terms of the lawyers that are appearing and in terms of the pro se people that are appearing, the people who are representing themselves, to set the people up who are in front of me to have the best chance of success and level the playing field for them to come in and do what they need to do to be heard. It's just like coaching youth sports, right? I mean, every team I had was an exercise in figuring out how do you set this kid up to be successful. And they may have been the worst athlete on earth, but you find the thing that they can do, the thing that they can do to help the team out and to feel successful themselves. And we do that every day in court as judges as well. You know, somebody may walk in a criminal case and they just may look dead to right on their case. I mean, it may be on video what they did and it's not looking good for them. But I'm going to make sure that that courtroom is still a respectful place for them and that they are getting a fair and respectful process. So coaching youth sports is probably my most impactful precursor to the bench.
Probably my most impactful community service involves my work at Neighborhood House. Is anybody here familiar with Neighborhood House? It's a social service agency on the west side. I taught English language learner classes to refugees and immigrants for many years, which was an incredibly fulfilling, wonderful way to give back to the community, and also aligns with my own personal background. My great-grandparents emigrated to this country from Greece, and they didn't speak any English, and it was challenging growing up, seeing them try to navigate systems and business, having very limited English language skills. And so that was a really impactful activity personally for me, and also to give back to my community in that way. I also think that it sparked in me my empathy and compassion gene that translates really well, especially to the work at the district court, to understand the circumstances that bring people to court. And I think it continues with me at the Court of Appeals when I don't necessarily see the litigants face to face in front of me all the time, but it's not difficult for me to imagine or understand the circumstances that might have given rise to the issues that we're seeing at the Court of Appeals. And having that carry through is really important so that the litigants and the parties understand that, you know, we appreciate what those circumstances are, and we understand that not everybody comes from the same background, and we all face challenges. I will just say that I've worked with everybody on this panel, and we are all kind and generous, compassionate, lovely people. I mean, it is true that maintaining a courtroom at the appellate level and the district court level of respect and to be a good listener and to have an empathetic heart and mind it's vital to the work that we do. And it creates a lot of trust and confidence in the outcomes that we are reaching, that litigants they understand that we have heard them, that we have listened to them, and that we're making a fair and reasoned decision, understanding those circumstances. And having those qualities is really important to being a judge. I just want to assure you that my colleagues here have that quality.
I hope no one thought I was saying they weren't kind.
It's about me now.
Judge Frisch is very kind. And another thing we have in common is my father is an immigrant from Greece. And there aren't that many Greeks in Minnesota, but I'm sitting right next to one, which is kind of fun. So what was the original question? Community service. One thing that is important to me is food security. And so in a couple of different capacities, I have volunteered to deliver food to people. My daughter's actually here in the room, and when she was younger and still living at home, we used to deliver meals through a program in Minneapolis called Open Arms to people who are ill. And it was a wonderful time that we got together. And there's just something so joyous about bringing someone a meal. And I was able to continue that work at the Minnesota Court of Appeals, which has a cooperative agreement with Wilder Foundation and Meals on Wheels. And I'm trying to bring that to the Minnesota Supreme Court as well, because we all need food. Is that the extent of the question?
You got me. I'm reading all these other questions.
Do we have a lot of questions from the audience?
Yes, we'll get to the audience very quickly. I was going to ask one more question.
We don't have time. Because you have all kinds of questions.
I think our time is limited, so I have one more question, and then I think we'll do kind of a lightning round. I'll ask a question that came from the audience and ask whoever wanted to volunteer to answer it. And we can have more than one person answer it, but I think so we can get through these questions, we will do that. But my last question is, how do you get feedback from citizens? You have other judges judging your performance or giving you feedback. You have mentor judges. You have attorneys that sometimes give feedback. But what about the common person? And I know I have heard things, too expensive to file a lawsuit. It's not accessible. Takes too long. How can you have a case come to trial 3 years after an event? What do you say about how you can keep in touch with the citizenry and find out what their needs are?
I think we have attempted, well, first of all, I'll say that it's really important that we get feedback. And it is one of those jobs where frankly, we don't. We don't get it. We'll get it from our colleagues. We generally won't get it from lawyers and from the people that appear before us. And we don't get it from the public. And I think it's important that we do that. One of the ways that we need to figure out how to do it better is by us having engaging the public, doing events like this. Or we recently in Ramsey here had a engagement process to learn more about why certain folks don't come to jury duty. In order for us to be able to get a balanced jury, a diverse jury, it was important for us to have a better understanding what those obstacles were. And while you might have an idea that of what they are, the $20 a day that we give individuals who miss a day of work to come to jury duty, or the fact that they're missing work, the fact that they don't have anybody to care for their children, or whatever that might be. There are a lot of obstacles, transportation, and learning, hearing that from the public makes it just so much stronger for us to advocate on behalf of those needs. So I think it's it's important for us, I think, to engage the public, because it's not something that we do. I mean, that the public does. The public generally, I mean, I'll get mail. I mean, when I get a mail from the public, it's good most of the time. I mean, it's mostly good, but it doesn't come that often. And I would be very open to getting more feedback from the public.
Echo that. There are a number of us in Ramsey County right now who are talking about and organizing these community outreach events. This event that we did at Wilder recently was fantastic. And when you create the right environment, people aren't afraid to tell you what they think about what you're doing. And we need to be open to hearing that. This administrative work that I referred to earlier with our justice partners, we hear about it there too. They tell us, you know, you have to develop the relationships with people so that they trust that you are open to the critical feedback as well as the good feedback. A number of us will often, and this is a smaller pool obviously, but we'll talk to jurors after jury service. After a trial is over, we'll stay back and talk with them completely off the record and ask, what did you think about? What constructive feedback do you have? How was this process for you? What were the barriers to you showing up? And explain to them sort of what we're doing to address those things as well. So there's a lot of that conversation in the moment. You know, a lot of folks in court aren't afraid to tell you exactly what they think about what you're doing as well. And there's a seed of truth in that as well, even if it's angry feedback. I try to understand where they're coming from with it and if there's something that we can and should be doing about it. So we've got organized efforts that we're undertaking as well, but the informal conversations that happen in the moments in the middle is where I get a lot of the real dirt and a lot of the things that I take the most action on.
I'll just add two things. I told you that I've been at the chief for 12 days. I will tell you in the first 12 days, I have already put the wheels in motion to expand the outreach efforts of the Minnesota Court of Appeals. And we have a work group that is going to develop a structured program so that we can engage in this important outreach. I will also say that the Minnesota Judicial Branch has an access and fairness survey that it conducts every several years, where we do formally solicit feedback from our court customers, litigants, attorneys, anyone who's appeared in court has the opportunity to provide feedback, and all of those reasons, and there's targeted questions. The surveys are sent by email, or they're available on kiosks right after you leave the courtroom, so they're convenient to fill out immediately or later if that's more convenient for the litigants or for customers. So we do have some targeted efforts, and I know that there are additional efforts that are underway so that we can continue to improve the solicitation of the public's feedback. I think it's vitally important, and I think that the leaders in the judicial branch agree that it is vitally important that we give meaning to providing service to the public. We want to make sure that we are providing the service that the public expects of us in discharging our function.
Yeah, I'll just add that we work for you. You are our bosses, and we serve you as members of the public. And it is critically important that we get your feedback as to the job that we're doing. And it's also critically important to us that you understand what we're doing, that we are transparent in the work that we're doing, and that the work we're doing is more accessible to the public. To that end, there are a number of programs. I know the Court of Appeals has some. The Supreme Court will actually hold oral arguments in high schools twice a year. We'll go outside of the metro area. We'll have a community dinner the night before and invite members of the public and high school students to actually observe the work that we're doing. And that gives us a wonderful opportunity to interact with folks we might not have the opportunity to talk to otherwise. But I also want to invite you to go to our courtrooms. If you have some time, go check out a trial in Ramsey County District Court. The courtrooms are open to the public. What we do is public. Go to the Minnesota Court of Appeals or a Supreme Court argument. And you actually don't, to see an appellate argument, you don't even need to leave your home. The Minnesota Supreme Court arguments are live streamed, and you can access all of those arguments through the Minnesota Judicial Branch website. So you could just tune in and watch an argument yourself and see what happens. And I really encourage you to do that so that Yeah, we can sit up here and explain what we do, but until you see it in action, I think it can be sort of difficult to understand. So please take the opportunity to get to know us a little bit better. And again, thank you for coming today and taking this step. I think a forum such as this one is just an excellent opportunity for us to get your feedback and for us to explain what we do a little more to all of you. So thank you.
Okay, we'll go with the lightning round. Is this microphone? No.
I'm passing this back. I'll just say that Court of Appeals arguments are also live streamed, so you can do double duty if you'd like.
Okay, it is working. All right. Question about elections of judges. Should Minnesota adopt retention elections for judges? Explain what a retention election would be.
They could take different forms.
I think we can say what it is.
Yeah.
A retention election is a vote to keep a judge or to not keep a judge. But because we're judges, we are prohibited by the rules of judicial conduct from advocating or stating a position on an issue that may be contested or controversial. So I don't think it would be appropriate for us to comment on that. Unfortunately, I'm sorry.
And just an explanation of what a retention election is was helpful. But that,
I'm talking to it, talking to it.
okay, better?
No.
Switch.
Do you want the mic we have over here?
I'm sorry. There's, all right, the question is there a code? I can break them all.
Testing, testing.
Okay, is there a code of conduct for judges, ethics for judges, for all judges and justices? Who writes or creates this code of conduct? Who enforces them?
I can answer that question as I walk back to my seat in the interest of time. Yes, there is a code of judicial conduct that is approved by the Minnesota Supreme Court. That code governs the conduct of all state court judges in Minnesota. The compliance with that code of conduct is enforced by an independent organization called the Board of Judicial Standards. That organization is charged with investigating complaints and prosecuting complaints against individual judges. In serious cases, that organization will ask the Minnesota Supreme Court to appoint a panel of fact finders. Sort of trial is then held before that panel, and then that panel makes a recommendation to the Minnesota Supreme Court as to the discipline to be imposed against a judge.
Who helps you in terms of the work that you do on a day-to-day basis? And is AI starting to be used in the judicial system?
Please take it.
Thank you. Great questions. We in Minnesota, and I guess I will speak for Hennepin County, they're a little different. But we in Minnesota, as trial court judges, all have a law clerk assigned to us. Not assigned to us, I guess we hire a law clerk. And we also have a court reporter that's as part of our chambers. When it's our chambers team, it's the judge, the law clerk, and the court reporter. And law clerks, for the most part, are lawyers that just recently graduated. And some of them stay for long periods of time, but most of us have law clerks for about 2 years. And then we have them go and practice law, and then we hire another one. That's generally who helps us. Certainly, we have court administration that helps us, and we help each other in a lot of ways as well. So how many people did you say were in the judicial branch? 2,500. The vast majority of those folks are actually court staff. that assist us with our work.
And to that, Court of Appeals has different set.
Yeah, at the Court of Appeals, we have, each judge hires 2 of their own law clerks, and they assist with the written opinions and the research and the writing process. And then we have additional law clerks that are shared between 3 judges. So every judge has 2 1/3 law clerks. And then we have some administrative assistants, executive assistants that are also shared between many judges. And then we have some staff attorneys who are subject matter experts in their areas. And those staff attorneys are extremely helpful to us because we do sit in panels of 3, but the staff attorneys, for example, our criminal staff attorneys, read all of the criminal cases that the court decides. So there's some internal checks to make sure that we're providing consistent communication as to areas of the law among different panels. And then there's court administration. I mean, the Minnesota Judicial Branch is a coordinate branch of government. So we have IT and HR and all of the other infrastructure that any organization would have. But I assure you, we run very lean. we could probably use some more assistance to effectuate the work that we do. But we have a very structured program so that we can get our work done.
I don't have much to add to that. We also at the Supreme Court work with law clerks. We have fewer law clerks than at the Court of Appeals, but very similar structure in terms of attorneys who help advise the court on decision making and read our opinions, and a number of administrative staff as well who help us get that day-to-day work of the court done.
About AI.
Oh, AI, sure. So AI is it depends on what you mean by AI. As judges, we are using AI a little bit. For example, Westlaw, which is the big legal search engine that is used to research case law, statutes, you name it. It's a tool that many lawyers use. AI, or Westlaw rather, has recently developed an AI function that can help. It's just sort of a new search engine that is AI based, and that is something that we can use to assist us in our research. In terms of our decision making, however, nobody can make a decision like a human being, at least at this particular moment in time. And so judges are not using AI to assist them with the actual tough decisions that they have to make every day. They're using it more as a tool to ensure that their research is comprehensive and accurate.
I'll give this one to you again. Is there a rough equivalent to an amicus brief that private citizen who's not an attorney can file on a particular case before the Minnesota Supreme Court?
A private citizen, I guess, could apply for amicus status to have a voice in a particular kind of criminal case or case before the Supreme Court. However, this is something that I personally have not seen done before. Typically, the world of a case is a somewhat closed universe. You have to apply for amicus status. Otherwise, you have to be a party in order to submit a brief to the court and to voice your opinion within the context of a particular case. And an amicus has to demonstrate some kind of particular interest in the outcome of a case. For example, an amicus might be an organization that is focused on a particular substantive area of the law for deciding a criminal issue. For example, the Minnesota County Attorneys Association might ask to submit an amicus brief, and the Minnesota Public Defenders might ask to submit an amicus brief, and they can, sort of clearly make the case as to what their particular interest in the case is. So if a citizen were to want to do that, they would have to be able to demonstrate some particular perspective that could be given to the court and some particular representation that they have that could provide that valuable perspective to the court.
Well, there were a number of questions that we haven't gotten to yet, some about the rule of law on a national level. I'm going to skip by those because this is the Minnesota judiciary, and there has been obviously a lot of respect for the rule of law. However, there was one question about why somebody might seek a judge because this one is particularly lenient or favorable on this particular type of case. So if everybody's coming from the same body of knowledge, the same precedents, how do you get those differences?
Goodness sakes. All right. Well, so cases are assigned, I don't want to say randomly, but they're assigned in the civil realm on a wheel, essentially. So you're going to have a fair shake at getting any given judge. Every litigant in a case has one opportunity to remove a judge as a matter of right, for whatever reason you have. If you think they're a cupcake or if you think they're favorable, whatever it is, each side, each party in the case can remove someone. After that, the only way that you can remove a judge who's assigned to a case is if they have bias. And you're entitled to have a hearing in front of the chief judge in the district to determine and to show if you think that they have bias. Otherwise, you're essentially stuck with who you have. And this sort of gets back to, I think, the underlying simmering question that was behind the election piece, which I'm not going to touch that piece of it. But I did want to comment on the importance of having impartial and fair judges on the bench, and nonpartisan sort of a situation on the bench. We can't have judges who are beholden to special interests. We can't have judges who are not judges who are acting impartially. And we've been so lucky, and it's not just luck, it's been a lot of hard work in Minnesota to hold the line on the impartiality of our judicial election and appointment system. And I just think I'd really be remiss if I didn't comment on how important it is to keep it that way. So this idea that you're going to have a judge who's, bent one way or another, probably not in your case, because we work hard to make sure that our system is not designed that way, and that the judges that we have are impartial and not beholden to special interests.
Say something.
And we do have a responsibility, an ethical responsibility, to remove ourselves from a case when we feel that we might have some form of bias, for it or against it, or even the appearance of bias. Even though we think we could be fair on the case, if something about the litigants or the subject matter would give the appearance of bias, we have a responsibility to remove ourselves from a case.
I apologize for not making through all of the questions, but I will refer you to the Minnesota Judicial Branch website. It has a ton of information. It will tell you where the courts are located. It tells you how to access oral arguments by the Supreme Court or the Court of Appeals. It has just an amazing amount of information if you're interested. I want to thank our judges and Justice for being here today. And I appreciate your candidness and your connection with the community. Want to remind you of the upcoming candidate forum and the election. The candidate forum for the House Minnesota District 40B is January 16th. The election is January 28th. Most of all, I want to thank you, citizens, for being involved, for being here. Thanks to the League of Women Voters of Roseville for sponsoring this. Special thanks to Chris Hansen and Margot Bach for all the help that they have given in putting this together. And This is going to make our whole country, our whole state stronger when people know about the judiciary and know what's happening, and supporting the judiciary is a key foundational thing in our democracy. So thank you today to everybody. Refreshments, information on the table, League of Women Voters, if you're interested, sign up. And again, thank you.